Yeah, good day, dear esteemed viewer, and welcome to our today's edition of Citizens and the Law. Citizens and the Law is a program aimed at letting the citizens know their rights, defend these rights, and become law-abiding citizens. In our today's edition of Citizens and the Law, we are going to look at the law of evidence. Very vast, very big, but as much as we can, we are going to compress it. And I have with me here in the studio two powerful gentlemen, one from the police force, the other person is a lawyer. By my immediate right, I have the boss of Fege Police Community, the Chief Superintendent of Police, the DPO of Fege Police Station, in the person of Rabiu Garuba. Chief, you're welcome to the studio.
Yeah, thank you, sir.
Okay, on the other end, I have a gentleman from Nigerian Bar, and that is talking about Barrister Chika Okeke, a strong man in the legal profession. Chika Okeke, counsel, you're welcome to the studio.
Thank you very much for having me.
I am the presenter of this program. Jude Mascot Obiago is my name. Like I said earlier, the topic for today is the law of evidence. That will somehow get at hearsay. But even if we don't fully get at hearsay, we are driving back to that hearsay in our subsequent edition. But for today, the law of evidence. So I want to start from you, counsel, directly as a lawyer. I want you to tell us what law of evidence is talking about. And from there, how does evidence help the court in arriving at decisions in difficult cases? Start from what the law of evidence is.
Well, I think it's proper to start with a short definition of the term evidence. Evidence generally may be viewed as the fact or facts which are placed before a court in order to maintain an action before the court. So it is a fact or facts which are placed before a court in proving a claim before the court or in defense of a claim before the court. And so we find out that evidence plays a very vital role in determination of any action before the court, because without evidence, no court or tribunal can arrive at any decision. So it plays a very vital role. And then back to your question properly, law of evidence is the branch of law that regulates all issues pertaining to evidence. All the issues, and you find out that it's a very serious issue, and in most jurisdictions, including Nigeria, you have a specific law, a specific federal law that deals with issues pertaining to evidence. This is so because issues pertaining to evidence is in the exclusive legislative list. What that means is that only federal government could regulate issues or legislate on issues pertaining to evidence. Here in Nigeria, the instant law is the Evidence Act 2011. That's the extant law in Nigeria that regulates issues pertaining to evidence in Nigeria. So as I stated before, law of evidence is the body of law, the branch of law that deals with issues pertaining to giving of evidence in courts. Thank you.
Chief Rabiu Garuba, to the extent of how it helps the courts, and again, what the evidence is. Because people used to come to you on your station, and there are a lot of claims, allegations, and counter-allegations. What you look for is evidence to prove anything there. So can you come up with your own aspect of the definition and just like that, yeah.
Okay, you see, he has already done justice to the topic, but the concept of evidence in our own perspective actually, as you rightly say, it is under exclusive legislative list, part 1, second schedule of 1999 Constitution. Likewise, we too were established under section 5, that is under executive function and police, in particular under section 214, and our duty is to ensure we detect crime. Then in the course of detecting crime, the onus of proving the case lies on us because we specialize or were limited to criminal offenses. In this vein, I'm not going to look at evidence in civil matter, but rather I'll narrow myself in criminal cases. As you rightly say, evidence has several definitions, but I can see the one that encapsulates the ingredient, more especially to we police in the course of our investigation. Evidence can be seen at all legal means exclusive of mere argument, which tends to prove or disprove any matter of fact, the truth which is submitted for judicial investigation. So in this vein, once a matter was reported to us, we are not magicians, but we are synonymous to researchers. Therefore, we can scout for evidence to show whether the fact exists or the fact does not exist. So that's to say evidence is of two faces. It's either to prove a case or to disprove the case. And once we gather that evidence, that's what will give us prima facie a ground for us to go for prosecution on behalf of the state.
Okay, Counsel, what process does it take for the acceptance of evidence and facts in a court of competent jurisdiction?
Well, actually, you find out that Nigeria adheres to adversarial system of justice. What this means is that courts are not allowed to descend into the arena and begin to scout for evidence. In other words, evidence must be presented before the court before it could be accepted or admitted in evidence. So you find out that here in Nigeria, the manner of bringing a piece of evidence before the court depends to a very large extent to the nature of the suit before the court. Where in a civil matter, a suit is commenced by writ of summons, you find out that a witness will be brought to the court to give evidence. And if the witness has any document which he intends to bring before the court, we deliver the court, the document will be admitted as exhibit. But where the suit is commenced by originating summons or by mere motion or applications, you find out that the evidence will come by way of affidavit. In law, we normally say that cases like that are fought merely on affidavit. And if the person handling the matter intends to introduce or to bring before the court or to make any documents or any other material part of his or her evidence, the person will exhibit that document or that material in the affidavit in support of the application or in support of the motion and mark it by himself, not court marking it. So as I stated before, to a very large extent, it depends on the nature of the matter before the court. But in criminal matters, generally, you find out that the witness will be called in court. The witness will come to court and testify before the court. This is so because in criminal matters, you find out that the issue of front-loading of documents do not apply. So the witness will come to the court and testify. And as I stated before, if there is any document the witness intend to bring before the court, with the leave of the court, the document will be tendered, and if it is admissible, the court will admit the same and mark it accordingly. So as I stated before, Nigeria adheres to adversarial system of justice, unlike in some other jurisdictions that adheres to inquisitorial system of justice, whereby the court or whoever that is presiding will be allowed to descend into the arena and begin to scout for evidence. But that is not applicable in Nigeria. In Nigeria, you must bring the evidence before the court could be allowed to act on the same. Thank you.
End at evidence, or are you stretched towards getting the facts?
No, the point, because the difference between the fact and evidence is like the difference between 6 and half a dozen. So it's just a mere technical term. Because you can't have evidence outside the fact. You understand the point I'm making? So there is a mere technical issue. It depends. For example, if the suit is fought on pleadings, you find out that the pleading will be technically called facts. In pleading, you plead facts. Then your statement under the oath that will contain almost the same thing in the pleading is termed your evidence. So you find out that the same facts, that the same information or material that constitutes a fact will at the same time constitute an evidence. So it depends on the name you call it. Thank you.
Chief Rabiu, a lot of people have died. They try to tender evidence and facts in courts. And I don't know, the only lies on the police to give these protections. And more so, what is happening in Nigerian society. Some people are found guilty, maybe their television or something of that clamped down. The court goes ahead towards provision of evidence, reopens. A lot of things like that around, and people are always afraid, coming to tender evidence in court. So what's your submission in this area as a policeman?
Okay, before I went further, I would like to highlight a little in the area that he made. He made mention of advisory, inquisitory. Like South Africa, they practice inquisitory. That means the court will investigate. Yeah. But in Nigeria, it is our statutory duty to investigate. Like in civil matter, it's based on the preponderance of evidence. If two of you come, the way the evidence till, that's where the judgment goes. But in criminal case, the onus lies on us to prove our case beyond reasonable doubt. But for the matter of time, I'm not going to go in depth to say even where the burden is shifted from prosecution to defense and etc. So in order to make it more clearer, this evidence is classified into three. We have oral evidence, we have documentary evidence, we have real evidence. So in the matter whereby you are there to prove your case, all these kind of evidence are admissible in court. Oral evidence, that is the one that the witness, what he perceived with his 5 common senses, will appear to testify in court to show whether the fact exists or the fact does not exist. While documentary is a presentation of documents. In law, we call it res ipsa loquitur. The document will speak for himself. Once you tender the document to show whether the fact exists or the fact does not exist. And that's where we are going to discuss on primary and secondary document. Primary original, secondary, that is a duplicate or certified copy of that document. Then the real evidence is a presentation of any physical object which is in connection to the commission of crime. So a gun that the armed robber used will be tendered to show this is the gun he shot the people with, or in the case of murder, manslaughter, armed robbery, and etc., or the knife that somebody caused harm to another person. We can tender them in the court for the court to be convinced that this is the object that the accused person used in commission of the crime. Then coming to the protection of our witness, the witness, whoever go to testify or give information to the police, are protected by law. These are privileged information. Be it lawyer, be it a police officer, judicial officers and police officers are protected by that the same Evidence Act, not to reveal the source of their information. So when we get an information, we don't need to reveal the information. That law is meant purposely to protect all our informants. So in an event where people are giving evidence and later reveal, and maybe the group of the criminal later put them on the run, that system is so archaic and we have already shown it out. So now, for instance, we see the hierarchy of police authority make the way of getting information to come only through the head, so that as a head, they believe you have a responsibility and you are more exposed to protect the information. So those are witnesses and so on are well protected. That's why the cases of hunting our witnesses is no longer the order of the day. But the few exceptional instances, we're still fighting over to make sure everybody will go and give information and sleep in his house with his 2 eyes closed.
Okay, thank you, Rabiu. Garuba, I want to ask you, Rabiu, directly right now, are there facts that do not require positive proof of their existence? Are there facts that do not require positive proof of their existence?
The fact that they speak for themselves, they don't need any proof. I hope you're getting me. Let's say, for instance, you now arrest somebody under medical practitioners and dentists Act Section 14 of it, that they are accusing him of being a quack medical doctor. And for him to prove that he's a licensed, it's left for him to prove not for us to prove the matter again. Like you are driving without driving license, the onus lies on you to prove you are a licensed driver. So in that situation, we don't need any proof from the side of the prosecution rather than the accused person.
Counsel, can you expand this?
Oh, well, of course, yes. By way of addition to what he has already stated, well, you find out that under Evidence Act 2011, you find out that there are a number of facts that do not require positive proof. And one of them is a fact which the court is bound to take judicial notice of it. So where a court is bound to take judicial notice of a particular fact, you will no longer be required to prove that fact. In Nigeria, for example, you find out that courts are sometimes permitted to take judicial notice of some customary laws. And once judicial notice of it has been taken, you no longer need to prove it. And then another one is court is equally permitted to take note of admitted facts. So we find out that once the adverse party has admitted a particular set of facts, you don't need to prove it any longer. And then we find out, too, that there is what in law is called a presumption. So once there is a presumption, the burden is not on you to prove the facts. The burden will automatically, by operation of law, shift the burden to the other party to prove it. And until that party proves it, you are not bound to prove the same. And then you find out that there is also what I think is Section 8 of our Evidence Act. There is something that is called a fact of common knowledge. In a fact of common knowledge, you are not required to specifically prove it. Take, for example, the Imoka Festival in Oka. It is a fact of common knowledge within Oka and its environs that once every year they have their Imoka Festival. So whenever issues pertaining to the existence of Imoka is before the court, the party asserting the same is not required to prove the same because the court within this locality is required to take notice of it because it is a fact of common knowledge. So there are so many issues that
boy under 13 years cannot commit rape. It's
Yes.
irrefutable presumption that
Yes.
laws has already presumed. In case he rape anybody, there's no need to prove that the child under 13 can commit rape. Issue of capacity is
Yes.
coming up.
Okay, dear esteemed viewer, you are watching Citizens and the Law on ABS Television, Channel 2 for Oka, on Star Times 113, and Metro Digital 29. And with me here in the studio, by my immediate right, is the DPO of Fege Police Station, CSP Rabiu Garba, and at the other end, I have Barrister Chike Okeke doing justice to the topic. Once more, the topic is law of evidence. In case you want to call us, you can use any of the numbers below there. We have 09070 627 627-2419. I repeat, 070 627-2419. The other line, 090 729 72090. 090 729 72090. Please, if you want to call us, you have to tune down the volume of your TV set so that we can hear you clearly. If you want to send a text message, you can do that on 090 232 73484. The numbers are all clearly written on the screen there. Okay, let's embark on a short break. We'll be back shortest time. Counsel, are there conditions for rejecting evidence in court? Then after that, are there conditions for rejecting evidence in the police station? Start from the court aspect.
Well, of course. There are a number of conditions which must be met before a piece of evidence could be admitted or be admissible in court. And I find out that the whole issue pertaining to admissibility of evidence in Nigerian courts is centered on relevance. So you find out that where a piece of evidence or a piece of fact is not relevant to the issue before the court, you find out that that piece of fact, that piece of fact cannot be admitted in evidence. So a fact or evidence that is not relevant in the issue before the court is not admissible. Then you also find out that if the piece of evidence is a mere hearsay evidence and the proper foundation was not laid for its admissibility, you also find out that that piece of evidence will not be admissible. And then also you find out that if the evidence is obtained through fraud or under duress and or through compulsion and all that, or promise of a gift or things like that, you'll find out that that piece of evidence will also not be admissible. Okay. So there are a number of conditions that must be met before a piece of evidence will be admitted in a court. Thank you.
Finally, let me hear from Rabbi Garba before we round up, because our time is almost gone.
As you rightly say, once evidence is obtained under threat, duress, or promise by the person in authority, such evidence is rendered inadmissible. Like more especially, a confession statement must be free and voluntary. So no element of torture, threat by a person in authority. Then, for instance, like hearsay evidence that is say it is generally inadmissible in law, but there is an exception, and that's Section 33, subsection 1 of the Evidence Act, Carbon 1 Laws of the Federation, 1990.
Hello. Hello?
Hello.
Yeah, good afternoon. Your name and location, your question.
Yeah, it's Prophet.
Huh?
Okay, it's Prophet from Oka here.
Okay, go ahead and ask a question.
I can't have evidence to give to police. They will not follow the evidence. That's the problem.
Okay. I understand what...
This is not the evidence, this. So it's a big problem in this context.
Okay.
Can you cite example of such evidence? Can you come up with one example of such evidence which, if you give to the police?
Like all these bad boys, they will carry them, give to police. They will bear them, say that is not the evidence.
Okay, let me respond. He's talking about giving information to the police as an informant. You see, here we have a lot of challenges. Somebody will arrest a bad boy and hand over to police, and he will abscond. He say he don't want to surface and give testimony to what happened. They may even arrest a thief in the open market, and they will recover what is stolen from him and give the owner, example, telephone. But when they ask them to come and make statements, so they will now tender this as an evidence in court against the accused person, they will all abscond. Police will be incapacitated. If you go to court and you don't have a tangible evidence to show, it is not difficult, it's not feasible. And secondly, sometimes they will give you information, they will not follow it up. If you give an information to police, follow it up, so that at least police will now have somebody. If you go to court without the witness in Anambra administration of justice, they will send the person away.
I think we are going to do part 2 of this. We are going to look into the security of people who bring evidence to the police and to the courts. This is Nigerian society, anything can happen, in as much as you are telling us the reasons. The other side, it could be what the gentleman is saying. What you are saying also is correct. So all of them are obtainable in Nigerian society. Okay, dear esteemed viewer, we want to thank you very much. This is where we draw the curtain in our today's edition of Citizens and the Law. It's unfortunate we could not finish up with what we have, but we are going to come back with part 2 of this very topic. I want to say a big thank you to the gentleman from Nigerian Police Community at Fege, the DP of Fege Police Station, CSP Rabbi Garba. Sir, thank you very much for coming. And I want to say a big thank you to the gentleman from Nigerian Bar over there, the other side of the row here. I'm talking about Barrister Chico Keke. Council, thank you very much for coming.
Thank you very much, and good evening
I
to
am
our
Jude
viewers.
Mascot Obiago, the presenter of this program. Until next week when we shall come back with part 2 of this program, thank you very much for being part of it.